Hi, and welcome to this latest immigration law update video. In this video, we're revisiting the question of indefinite leave on the basis of 10 years lawful residence, gaps in residence, the whole concept of disregarded gaps coming from the case of Hock, 3C leave, and Rule 39E. And given I've said that much already, you'll understand this is a complex subject. So if you're watching this is not legal advice. It's just a short summary, and do make sure you consult an immigration lawyer. What I'm doing in this video is looking at the case of Afzal and Ayaki from the Supreme Court on the 28th of November 2023, which looked at these questions. In previous videos, I've discussed the Court of Appeal judgment and the judgment of Sir Patrick Elias in the Court of Appeal case of Afzal. So I've shared my screen, and on screen you'll see the judgment of the Supreme Court, which was given by Lord Sales. Let me give you a bit of the background facts in Afzal's case, because they will be important. Look at paragraph 5, and you'll see on the 6th of July 2017, before the expiry of his leave, he applied for further leave and applied for a fee waiver. And that fee waiver was to waive the fee together with the immigration health surcharge. Now, the Secretary of State said on the 18th of October 2017 that they were rejecting the fee waiver application and gave him 10 working days to pay the fee under the Immigration Health Charge Order 2015. Well, Mr. Afzal paid the fee, but he didn't pay the health surcharge. So look at paragraph 8. On the 22nd of January 2018, the Secretary of State wrote to Mr. Afzal rejecting his application for further leave to remain. Mr. Afzal didn't challenge that decision at that time, but made a new application on the 2nd of February 2018, which was subsequently granted on the 5th of September 2019. In 2020, there was an application under 276B, so for 10 years long residence, and that was rejected or refused, forgive me, by the Secretary of State on the 11th of March 2020, and the Secretary of State held there was a gap between the 14th of July 2017, so that's when his original leave ran out, and the 5th of September 2019, when he was granted further leave to remain. That was challenged and it was unsuccessful, and the judgment of the Court of Appeal, as I've said, was from Sir Patrick Elias. Mr. Ayaki's case, the facts are set out here. I'm not going to go through that at the moment. We'll come back to that at the end. So Lord Sales sets out the immigration rules, 276A, which defines continuous residence and lawful residence, and then 276B. Obviously, we know from 1A that he has had at least 10 years continuous lawful residence in the United Kingdom. It's Roman 5 that has caused a lot of the controversy in regard to the disregards. There, the applicant must not be in the UK in breach of immigration laws, except that where paragraph 39E of these rules applies, any current period of overstaying will be disregarded. There's that word disregarded. Any previous period of overstaying between periods of leave will also be disregarded, where A, the previous application, and just hold on to that phrase, the previous application, because that will come up when we look at Ayaki's case in a minute, was made before 24th November 2016 and within 28 days of the expiry of leave, or the further application was made on or after the 24th November 2016 and paragraph 39E of these rules applied. Lord Sales then sets out paragraph 39E of the rules, and this case particularly looks at 39E 2B Roman 2. So the application was made within 14 days of 2, the expiry of any leave extended by Section 3C of the Immigration Act 1971. Section 3C, in terms of the extension of leave while you've got a pending in-time application, is set out at paragraph 25 of the judgment. And then we have extracts from paragraph 26 onwards of that 2015. So that's the Immigration Health Charge Order 2015. So the 2015 order is set out there. And that's where it gives in leave to remain applications provision to pay within 10 working days of the fee waiver being rejected. So that's 6.1b2. Lord Sales then sets out the case and the judgment of Sir Patrick Elias. He then addresses the first argument, that's in terms of Section 3C. So 2 issues in relation to AFSAL. Section 3C, whether that applies, and then the issue about the meaning of the word disregarded. All right, so first issue, Section 3C. Lord Sales agrees with the Court of Appeal that Mr. Afzal's application was conditionally valid. So he made an application with an application for a fee waiver. So that application is valid, but then when that fee waiver is rejected and he's asked to pay the fees within the 10 working days, the continuing validity of the application becomes conditional on him paying the fees. Look at paragraph 64 on the screen now. So he's entitled to Section 3C leave up until the point where his application ceases to be valid. He did not pay the immigration health surcharge within the 10 working days of the 18th of October 2017. So the application ceased to be valid and he could no longer rely on Section 3C from 31st October 2017 onwards, paragraph 64. So therefore, his application falls to be dismissed because he could not rely on 39E2B2 because his February 2018 application was more than 14 days after the expiry of Section 3C leave on the 31st of October 2017. So that's point 1, Section 3C leave. What about this word disregarded? So that comes from the case of Hock and the judgment of Lord Justice Underhill. Lord Sales agrees with the Court of Appeal that word disregarded, paragraph 73, is to be given its natural meaning. Effectively, what disregarded means is that any gaps don't break the continuity of the residence. So any gaps that come within 276B Roman 5 are to be disregarded. That means you can rely on the period of leave before, you can rely on the period of leave after and add those together. The continuity is not broken by the gap, but you cannot positively rely on the time of the gap towards the 10 years lawful residence. That's what's said in paragraph 73, and he says the word carries no other meaning. So in agreement with Sir Patrick Elias in the Court of Appeal, he found that disregard operates as a shield. So it protects you from the continuity of being broken rather than a sword. It doesn't positively add towards the 10 years lawful residence, paragraph 78 of the judgment. And this judgment disagrees with the reported decision, as did Sir Patrick Elias in the Court of Appeal, in Manib Asif from 2021, UK UT 96C, paragraph 80. So for those reasons, Lord Sales affirms the Court of Appeal's decision, paragraph 81, in respect of Section 3C and in terms of the meaning of disregarded, and would dismiss the appeal. Mr. Ayaki's case raises a different issue. He had paragraph 80 3 leave which expired on the 9th of August 2014. He was subsequently granted a period of leave on 28th November 2014. There was a gap within that period. Now, the argument concerned this phrase we've looked at already, the previous application. He had made a previous unsuccessful application on the 2nd of September 2014. That was within 28 days of his post-study leave expiring on the 9th of August 2014. Look at paragraph 84. So could he rely on 276B5 because of that previous application, even though that previous application was unsuccessful? Lord Sales said no, agreeing with the Court of Appeal and the judgment of Lord Justice Dingemans in that case, paragraph 85. Look at what it says. In my judgment, the previous application cannot be a reference to any unsuccessful application made in a period of book-ended leave before 24th November 2016. It must be the application that led to leave being granted. What Lord Sales points out is that it could have perverse results and encourage people to make hopeless applications and put them in better positions than others. Look at paragraph 88. So the Supreme Court dismissed Mr. Ayaki's appeal. Just a final comment, and we've come back to this a number of times in relation to the case law on long residence, paragraph 91 from Lord Sales. A final comment is in order. In cases dealing with this part of the immigration rules, judges have repeatedly commented on their poor drafting. Poor drafting needlessly creates difficulties and uncertainties which lead to expensive litigation. It is highly desirable that the project to redraft the immigration rules to make them clearer should be carried forward to completion. So clearly there, the Supreme Court saying that there needs to be more clarity in respect of 276B, which has caused so much problems and so much judicial ink to be spilt. I hope this video has been helpful to you. Thanks a lot.